Well, good evening, ladies and gentlemen. My name is Justin Cardy, and I'm the Executive Editor of the University of New South Wales Law Journal. It is a pleasure to be able to welcome you all here this evening for the launch of Volume 40, Issue Number 4, our final launch of the year for the last of the 4 issues that complete Volume 40 of the journal. On behalf of the journal, I want to extend a special welcome to our keynote speaker for this evening, Dr Roger Clarke. Dr Clarke is a visiting professor at the UNSW Faculty of Law and is an independent consultant in the strategic and policy implications of advanced information technologies. I would also like to extend the same welcome to Patrick Gunning and the partners and solicitors of King Wood Mallesons, to Professor Fleur Johns, the Associate Dean of Research at the UNSW Faculty of Law, and of course to the journal's editorial board and our journal alumni. It has been another busy year for all of us at the journal, and as 2017 draws to a close, it is an opportunity to reflect on the vital support of a great number of people that have helped to make the work of the journal possible. So I would like to thank some of those people now. On behalf of the journal, I would like to say thank you to our host and premier sponsor of the UNSW Law Journal, King Wood Mallesons. King Wood Mallesons have been a sponsor of the journal since way back in 1981. This long-term relationship between the firm and the journal is highly valued, and the firm's ongoing support is greatly appreciated. It is always a special occasion to come back and launch an issue here at King Wood Mallesons, and I thank Patrick Gunning as well as Kelly Mildred and her team for helping us organise tonight's event. I would also like to acknowledge the journal's other premier sponsors, Allens and Herbert Smith Freehills, for their continuing support as well. Being one of the few academic journals run entirely by voluntary student board, the journal is grateful to the Dean of UNSW Law, Professor George Williams, as well as to our faculty advisors, Professor Rosalind Dixon and Associate Professor Lyria Bennett-Moses. We thank them for their support, for their advice, and the encouragement that they provide for the students who make up the journal's editorial board. A special thank you, of course, goes to the journal's editorial board. The members of the editorial board collectively have edited each and every article in tonight's issue several times across the different stages of the publication process. They have done this with great skill, diligence and care, and we thank them for their work. As I mentioned earlier, this is our final launch event of the year. And of course, at the end of every year, there is somewhat of a changing of the guard as graduating students who are departing the editorial board of the journal move on to new roles, including as graduates in outstanding firms such as the one hosting us here tonight, as judges associates, or perhaps as postgraduate students overseas, including as Rhodes Scholars. So I would like to acknowledge the contribution that each of our departing members and our alumni have made to the journal over the years and wish them every success in their future endeavours. As it happens, this is also my final year and my last event as the executive editor of the journal. On that, I just want to say what an honour it has been to serve the journal over the past 2 years as a member of the executive committee, and what a real privilege it has been to get to know and to have the chance to work with each and every member of the editorial board. My congratulations goes to the incoming 2018 Executive Committee, and I look forward to following the journal's continuing success in the new year. Finally, I would like to congratulate the editor of Volume 40, Issue Number 4, Chris Chiang. The journal you now have before you is a culmination of many hours of hard work. This commenced more than 12 months ago with a proposal written and presented by Chris to the journal's editorial board. During that 12 months, Chris has steered the issue forward through soliciting submissions, coordinating peer review and managing the editing process. Realising an issue of the journal is a long 12-month process, but I have been very impressed by the dedication and the focus that Chris has brought to the role. It is a task, I would say, made all the more impressive by the fact that in addition to his duties as issue editor, Chris not only managed to maintain a full schedule of competitive mooting engagements, most of which he came out of as a winner, I might add, but he also managed to find the time to decorate one of the journal's office walls with delightful papercraft and origami. Despite the long hours and the demands of the role, Chris has, I am pleased to say, put up his hand to do it all again with another year on the Executive Committee as the journal's forum editor in 2018. So Chris, I'm glad that the journal will continue to benefit from your experience and your skills, and I'm sure that you will enjoy the opportunity to finish decorating the other 3 walls of the journal office with more delightful papercraft and origami. Congratulations, Chris. Congratulations on launching this issue tonight. It's a wonderful achievement, and it's been a pleasure working with you over the past 12 months. Now I would like to introduce Patrick Gunning to speak on behalf of King Wood Mallesons. Patrick is a partner with the firm who advises on a wide range of commercial and corporate transactions, with an emphasis on transactions involving material technology or IP. Patrick's practice extends over the full life cycle of projects and includes assisting clients to resolve disputes. So thank you again, Patrick, for hosting us here this evening. We're very happy to be here and we're grateful for your time in speaking to us. Thank you, Patrick.
Justin, thank you very much for that. Welcome to King Wood Mallesons. Before we start, I'd just like to acknowledge the traditional custodians of the land on which we're meeting, the Gadigal people of the Eora Nation. I pay my respects to elders past and present. It really is fantastic land that we're on at the moment. As Justin said, I'm a partner here. I'm a graduate of UNSW as well. I was probably one of the earlier people to graduate with law and computing science degrees. So it's a pleasure to have you here tonight to launch an issue of the journal that contains a thematic issue on cyberspace and the law, which is a topic that's close to my heart. For most of my career, I've been lucky enough to be able to combine my 2 areas of interest. After I graduated, I was fortunate enough to work with Graham Greenleaf, who's here this evening somewhere, and with another UNSW computer science law graduate, Andrew Mowbray, who had moved on to UTS at that point, and we worked on precursors to OSLI, which really is a fantastic service to the public and to the profession, and that free access to law movement. And we also worked on rule-based legal expert systems. This was the early 1990s, and that was before anybody had heard of apps for lawyers, which are very much in vogue now. So it's a bit bemusing to see how topical and keen people are now to be discovering stuff that a fair bit of work had been done on some at least 25 years before. I've also had a long-standing interest in privacy and information law, and through Graham, who has known Roger Clarke for a long time, and I've known Roger on and off through that period, and I'm looking forward to hearing what he has to say. He's always a thought-provoking speaker. Before I started practicing as a solicitor, I had a stint working in Canberra at the High Court, and I think that anybody who's had the privilege of working at that institution always keeps an eye out for the annual statistics on constitutional decisions, and I see that this issue here has got the Lynch and Williams annual numbers this time around. That was one of the general articles that caught my eye. And some of the other articles that are in there touch on issues that practitioners of the firm will and other firms like it deal with in the cyberspace area. And then there are articles that really are talking about things that, as practicing solicitors in a commercial or corporate firm, we really don't deal with. I'm thinking here of articles on the impact of social media on jury trials, for example. It's very rarely that we get involved in those sorts of cases. But I think that is as it should be. A journal like this one should be publishing articles that are of interest to academia, to policymakers, and to practitioners. And I think that this issue does that. So thank you again for coming along. We're very proud to be associated with the journal, which is a top quality publication. And I'm going to hand over now to Chris, who will give you a bit more detail on the articles which are actually included in this issue. Thanks very much.
Thank you, Patrick. I too would like to begin by acknowledging the traditional owners of the land on which we meet, the Gadigal people of the Eora Nation. I pay my respects to their elders, both past and present, and extend that to all Aboriginal and Torres Strait Islanders people here this evening. In making this acknowledgement, I also sincerely hope that positive steps are taken by both our society and nation to address the injustices of the past. Ladies and gentlemen, I'm very pleased to welcome you all to the launch of Volume 40, Issue 4 of the University of New South Wales Law Journal. Each issue of the journal contains two distinct parts, a general and a thematic component. The general component includes 7 articles, which explore contemporary legal issues. They discuss the protection of Indigenous cultural heritage and sacred sites, regulatory responses to trade union corruption, the inadequacy of ingredient disclosure for fragrance products, historical and contemporary difficulties with unsworn evidence given by children, the application of proportionality in sentencing offenders for breach of control orders, an economic analysis of issues arising with schemes of arrangement, and a long-running favourite, statistics on the High Court in 2016 and during Chief Justice French's tenure. The thematic component of this issue is on cyberspace and the law. Now, it's recently been brought to my attention that this is a particularly appropriate issue to consider this theme because it's issue 404. Unfortunately, I can claim no such foresight on that part, and it was entirely coincidental, but a happy coincidence nonetheless. The real catalyst for this theme was the ongoing discussion about how technology will disrupt the legal industry and how it's necessary for the modern lawyer to be innovative and agile, whatever that means. But I think one aspect that received little discussion by comparison is how technology will interact with substantive principles of law. The common law method has often been described as incremental, which implies that gradual change is achieved over time. The difficulty then is that technological development is often rapid and unpredictable, and there are real questions about whether the common law is able to keep up. Now, a simplistic answer would be to say, well, this is where other forms of regulation come in, whether it be legislative reform, industry best practice, or other forms of so-called soft law. But again, there's the difficulty of time lag between technology evolving on the one hand, and on the other hand, that regulatory reform actually occurring. Now, as Dr. Clarke notes in his foreword, there's a tension within the so-called principle of technological neutrality. Under this principle, regulatory requirements should operate effectively in different contexts, including in response to developments. Now, it's all well and good to say, well, we can just draft regulations that are sufficiently broad to deal with unforeseeable technological developments. But at a certain point, that high level abstraction, sorry about that, undermines the effectiveness of those rules. And we end up in much the same situation that we currently face, with a lacuna in the law where it's uncertain what principles are applicable. Therefore, there are two main issues that I hope to explore within this thematic. The first of these is how new developments in cyberspace and technology fit within our current legal framework. The second is how the law needs to change to accommodate these developments. Now, these questions are, of course, interrelated. By seeing how and why the current legal position is inadequate in dealing with new technology, this can shed light on what reform is necessary in the future. The 6 articles in this thematic engage with these questions and make an important and insightful contribution to this field of research. Something that's arisen within this theme that I found particularly interesting is the power of social media within the framework of the law. Given the ubiquity of social media nowadays, it's pretty hard to imagine a world without hashtagging, tweets, and a barrage of photos of smashed avo and chai. But given how pervasive social media is in our lives nowadays, it's telling that the law still hasn't figured out how exactly social media can coexist with traditional legal institutions. And I think that's a neat and relatable snapshot of the kind of challenges that the law faces in working out how it is to adapt in response to new technology. I would encourage all of you to read the articles in this issue and consider the challenges that they raise and the potential solutions that they propose. Now, of course, every issue of the Law Journal is a combined effort of a great many people, and I'd just like to take a moment to thank some of those people. First of all, I would like to thank David Vale for his assistance in the very early stages of designing this thematic. Thanks, of course, must also go to our wonderful faculty advisors, Professor Rosalind Dixon and Associate Professor Lyria Bennett-Moses, as well as the Dean of the UNSW Law School, Professor George Williams. Their generosity and mentorship, as well as their faith in us as student editors, is greatly appreciated. Thanks, of course, must also go to our premier sponsor, King Wood Mallesons, for hosting this evening, and also to our other premier sponsors, Herbert Smith Freehills and Allens. I can safely say, however, that King Wood Mallesons has by far the best view. I'd particularly also like to thank all of the authors, some of whom are here tonight, for entrusting us with their work and allowing us to publish it. I've greatly appreciated their assistance and patience throughout the editing process, and it's been an absolute pleasure working with all of them. This might seem a bit self-indulgent, but I'd also like to congratulate them on their publications in such a fantastic and well-respected law journal. I'd also like to thank the anonymous peer reviewers. Reviewing academic submissions is a time-consuming and often thankless task. But as a student-run journal, we're incredibly grateful for the generosity of academics who dedicate their time and skill in reviewing the articles submitted for publication. Their comments not only assist us in making publication decisions, but also assist authors in improving their already fantastic submissions. Now, of course, none of this would be possible without the hard work and dedication of the journal's editorial board. They're the ones who are sitting in the back and they're kind of sleep deprived. The board is made up entirely of students, and on top of their usual studies, they volunteer copious amounts of time to proofread every article and check every single footnote in the articles that we publish. And it's truly been a pleasure working with such a talented and tenacious team, so thank you. I'd also like to thank my fellow members of the Executive Committee. I've really appreciated your friendship and good humour, and you've made the last 15 months incredibly enjoyable and rewarding. I'd particularly like to thank Justin, the outgoing executive editor. Under his leadership this year, the journal has begun some exciting initiatives, such as the launch of the forum. As he's already alluded to, he's also humoured my attempts at doing some interior design work in our office, and I found that a really great way to de-stress when I'm in the middle of editing a particularly difficult article. And finally, on a more personal note, I'd like to thank my family and friends who have always supported me. None of this would be possible without your love, and for that I'm eternally grateful. It's now with great pleasure that I would like to welcome our keynote speaker for this evening, Dr. Roger Clarke. Dr. Clarke is a visiting professor at the UNSW Faculty of Law and an independent consultant in the strategic and policy implications of advanced information technologies. In 2009, he was awarded the Australian Privacy Medal in recognition of his research, consultancy, and advocacy work examining the privacy issues in the context of new technology. As a consultant, he has also developed expertise on matters such as cybersecurity, electronic payment mechanisms, e-democracy, and information privacy. Ladies and gentlemen, please welcome Dr. Roger Clarke.
Thank you. Thank you very much, Chris. And let me just check the technology first. Pardon me. As you'll see, I'm a consultant. And you'll understand that the first obligation of a consultant is to commit murder by bullet point. I have the impression that lawyers aren't used to slides, and I know that there's some very good reasons for that, some of which are complementary to lawyers and some of which are not complementary to lawyers. But I found out today why lawyers really don't want to use slides. Because these horrible screens get in the way of a fantastic view out there. And I assure you I will have no difficulty whatsoever if you look past me and admire the view. It's a wonderful physical space out there that us guys who are ex-Sydney but for a long time in Canberra do like to get back and see from time to time. Now, what we're here to talk about is cyberspace. And I'm afraid I'm a literalist and I like to understand what it is I'm talking about and to analyse things. So I want to take us back very quickly and remind us all, which way around do I hold this thing? That way around. Remind us all of what we already know about cyberspace. Because it's depictable with all sorts of lovely graphics. The graphic artists had a field day back in the late 80s onwards with depictions because William Gibson was so graphic in the way in which he described it. And you'll see I'm carefully giving you time to read the slides because I'm not going to read them for you. But Gibson's conception of it long predates the ability of technologists to actually deliver anything approximating what we think cyberspace is. I wish I'd learned to write larger scribbled notes on my overheads because then I'd be able to see them when I'm standing here. Sorry, I have to have my glasses on and off. Time has wrought its damage. So after about a decade, we did reach the stage where some of the sorts of things that Gibson was imagining in his books, you could place some construction on it as a technologist and say, well, it's a bit of an exaggeration, but actually things are heading a little bit that way. So art predates science and technology quite significantly. Now, there's a lot of different facets to what Gibson dreamt up. And all of these ideas, nobody's ever really tried to take the ideas away from Gibson. He dreamt them all, and we simply run with his images. And the notion of a graphic representation of data, his words that's from the 1984 book, of course talks to us about visualization technologies, as we subsequently called them when we finally managed to come up with some technologies that vaguely matched the sorts of ideas that he had. So that's one of the very important things, is that it is a highly visual sensation. The presumption was that we were strongly visual animals and that we would be able to grasp ideas far better if we could visualize them in some ways, and best of all, if something out there could enable that visualization or visualize it for us. But those weren't the only sorts of words that he dreamt up in his amazing typewritten books. He did all of his major works on typewriters, not even on PCs. And this other terminology of a consensual hallucination is absolutely critical to the whole idea, because now we start to bring in the ideas of networking technologies and immersion, the various forms of what we these days call immersive technologies. Those ideas were there from the beginning, before the technologies were there. So what sorts of things does a literalist like me come up with as being the elements that we have to grasp and deal with when we're working out the impacts of cyberspace on technologies, on people, and in this case, on the law? Well, the first element is that it's to do with an individual hallucination, but it's also to do with shared hallucinations and surprising degrees of commonality. Equivalent hallucinations across all of us and across many people spread across time and space, unlikely, but a great deal of commonality. And that's been a real surprise because in our day-to-day activities over the last 30 or so years, we've experienced that surprising commonality. Another is that I had to come up with a word that wasn't space and wasn't location and wasn't place, so I used locus. It's a bailout word. It's a locus of human behaviour. It's where things happen that humans do. And some of those things were intended by designers, and an awful lot of them weren't. And an awful lot of the interesting ones weren't intended by the designers. Some of them are bugs. It simply wasn't meant to work that way, and it's a malfunction from the designer's perspective. But there are also quite a few things which turn out to be useful, turn out to be functionality that's hidden away in there that the designer never dreamt of, but the designer isn't unhappy about, and the designer will subsequently claim. Retrofitting is a big game in the information technology industry. And again, Gibson got there first, because his term, the street finds its uses for things, absolutely sums up what the arts faculties and media theorists of the world mean by affordances. There's an awful lot of things going on out there that were not intended. But what's it mean now? Because that's all old hat. I could have said everything I've said up to now in the early 90s, mid-90s. In fact, I did say a lot of them because I did most of my writing in this area in the late 1990s. So what's new? What's changed? And does it matter that things have changed? Have things moved on? Do we have new challenges? The call for papers that Chris put out, there's words in there which identify particular kinds of technologies which are modifying the ways in which cyberspace happens. Some of them possibly for the good, and many of them certainly not for the good of humankind. It's also more than a communications infrastructure for humans, and it's not just something carrying data that will eventually help humans hallucinate. It's increasingly for machine-to-machine communications. M2M's becoming a bigger word, and the horribly misconceived idea of the Internet of Things, which is a total furphy. But if you take it apart and put it back together again, there are some very important points around the Internets of Things in this particular corner of cyberspace. And then, of course, cyberspace is rapidly becoming a locus in which machines behave. And that's a big change. That's the stuff of nightmares and a whole pile of other science fiction above and beyond Gibson. Now, having done the quick recap of all the things that represent where we've been and where we think we might be about now with cyberspace, when I sat down to read the papers in the thematic issue, I thought, well, I'm going to have a couple of themes myself. I can't cover the whole field. What sorts of topics do I think might be worth talking about and writing about in the preface? So before I talk briefly about the papers, I'm going to talk to you lengthily about the sorts of things I was thinking about. The first one was, as Justin or Chris, one of the two of you said earlier, was the technology neutrality principle. I've stolen a quote which was the best one I found quickly, which was from Larry Bennett Moses, previously mentioned today, also a colleague and co-author of mine. And that says quite nicely that that's what we're trying to achieve. In order to achieve it, what do? Well, we focus on functions. We don't get down too deeply into the procedural level. Fine. Why are we doing that? There are benefits. There are benefits to people who want to stimulate technologies, the winners, the kinds of people who take advantage of technologies and don't want to be disadvantaged, and then the kinds of people who are at risk of losing also need some kinds of regulatory protections. And if we can fulfill this principle of technology neutrality, won't that be good for all people concerned? And yes, it's a very attractive idea. And I've spent an awful lot of time explaining to people why I don't think it's a workable idea. And the images that I've used in most of my explanations of this have not got to do with the law. They've got to do with nasty things that go bang. Because what we need to think about is, well, what? Big and dangerous things. So mines, I didn't mean mines that go boom, I meant extractive industries and quarries, chemicals factories and power plants are the sorts of things that you need to focus on. And I went looking for those examples. You may or may not have recognised some or all of those. The ones with the really lousy photographs happen to be the oldest ones, top left and bottom right. They're also the two from very much the free world where Freedom of Information Acts exist and all those sorts of things. And do you think it's easy to find photographs of Windscale and 3 Mile Island? No. Have a little think about that one. Chernobyl is quite easy to get photographs of, but that came from one of those horrible countries that was secretive, right? And Fukushima, that really was in the world's gaze. Now the point about this is technology neutral requirements, functional statements about you must be safe don't get us very far. There were very, very specific risks that were not handled adequately in each of those 4 instances. And it's very specific kinds of regulatory measures that you need in order to guard against those kinds of accidents and what could have been, in each case, a lot worse than those kinds of accidents. So the key point about technology neutrality is it is extraordinarily difficult because when you get to really dangerous things, your needs are actually techno-specific, not techno-neutral. You've got to get down to tin tacks. Now, quite clearly, my target zone here is not nuclear power plants, about which I know precious little. My target zone is something different entirely. The basic point is that there are some things that are sufficiently different from all the other things that you've got to tackle them as themselves. It's no good trying to come up with generality when generality won't work. Well, let's run a little test on this because Chris used the law of the horse, which I didn't pick up until only a few days ago in his foreword to the issue. And in conversation with multiple people, I was delighted to receive feedback from about 8 of the 14 people I sent my paper to, which is a higher batting average than usual, I've got to say. And Graham Greenleaf spent some time reminding me about the law of the horse. It's an important question as to whether there will be insufficient depth of understanding if we simply come up with laws for horses or any other specific thing, rather than building on that wonderful edifice that is the law, or the many kinds of laws. The fact is, horses are different. And I've chosen one particular kind of horse that's particularly different, because Lipizzaner, how many people here have ever seen Lipizzanas at work and play? Absolutely stunning horses. I'm not a horse person, but these things are fantastic. There's an enormous amount of enormous number of regulatory measures involved in training horses like this in Vienna, by the way. So I think it's really important that we do have a deep understanding of not just horses, but even of specific kinds of horses and specific contexts when we're trying to come up with regulatory measures for horses. But it ain't just horses, cows are different. They have quite different kinds of needs. And I picked on a Swiss cow partly because brown feet are really, really pretty when you're walking up there in the Alps, but also because Switzerland has got some of the tightest regulations on cows anywhere in the world. And of course, some animals are laws unto themselves, and that opens up another can of worms. No, don't mix metaphors that badly, Roger. Sorry, that was unplanned, that one. And it's not just those kinds of animals. I picked on 3 animals, all of which are A, domesticated, and B, get eaten. The ones down the bottom right involve a completely different set of regulatory challenges. It's native, it's protected, don't eat it, please don't run over it. So we have to set up quite different kinds of frameworks and understand what it is that we are trying to deal with. You have to treat the thing as itself. The best quote I've ever found to support this in articles and in presentations, it's slightly long, it's on the next slide, but so you'll have to read fast before I take the slide away from you. It also deals in chelonians. Everybody happy with chelonians? How many people know what I'm talking about? Chelonians. It is in the dictionary. It wasn't just made up by the person who wrote the book that I'm depending upon here. How many people know Terry Pratchett and the Discworld? Terry Pratchett and the Discworld? Come on, you don't have to be embarrassed. Put your hands up. It's credible reading. The Discworld is to fantasy what Douglas Adams is to science fiction. It's spoof and splendidly done spoofs. It enables him to indulge all of his arts faculty philosophy from his university days and take everybody out at once. And to do that, he had to have a flat Earth, because you can't possibly have a sphere, could you? So the Earth travels along on the back of a giant turtle, 10,000 miles long. But it's the last bit that matters. Well, the rest of it is just setting. There is absolutely nothing you can realistically be like except yourself when you are a really big, complicated, specialised thing. The one I used to use back in my systems theory days, a long time ago, was that there is only one actually reliable model of a complex real-world system, and that is the complex real-world system itself. And from a simulation viewpoint and from a variety of different arenas in computer science and information systems, that's a very important insight to always remember. So technology neutrality was one of the things that concerned me as I came to these papers. The other thing that concerned me was technological understanding as demonstrated in the courts. Now, I've got a probably too lengthy section in the paper, which I'm not going to read to you word for word, because it's awfully heavy, from my first experiences in the mid-80s, when I examined the judgments involved in the case of the Wombat ROMs. The case of the Wombat ROMs was the case in which the courts determined in Australia that software was not a proper subject matter for copyright. And this made me very happy, because I thought it was an absolutely stupid idea that copyright, as it exists in the Copyright Act, should apply to software. We obviously needed something very specific. And I've had PhD students who worked on that very topic. I found a whole pile of things in those judgments which were amazing to read. And I've picked out a couple of them. Source programs afford instruction to the operator. The word operator referred to a human operator of computers in the context. And the other one was source code consisted essentially of instructions to be read and followed by a human reader. I don't know what counsel actually said, and I never went back to the court records to find out what expert evidence was left available to the judges of the High Court by the time it reached them in the third round. But each of those statements is utterly ridiculous, and there's no sensible construction that you can actually place on those words, and they were in the direct line of reasoning of those judges. This was my first introduction. I successfully published this article. I must say I published it in a computer journal, not in a law journal. It's a bit of a worry. Have people worked out what the left side and right side banners are? That clear to you? Well, I did my schooling about there, and you're somewhere, we're currently standing somewhere down around there. So it's the east coast of Australia. What's the other one? Chile. It's Chile. Why have I got Chile and Australia on this slide?
They're on opposing sides of the Pacific.
Yeah, they are on opposing sides of the Pacific, but on this occasion they were joined in something. I've not been able to quickly research whether it's still true, but at the time, these were the only two countries in the world that found that copyright did not subsist in software. Because the other trick is that right now there's an awful lot of worry about something that may or may not be on the bottom of the ocean around about here somewhere. Yeah, okay, so Chile and Australia have a number of things in common. But we have got to the World Cup. Chile hasn't. So my first introduction was a worry. What happened after that? Well, I've done something over 20 expert evidence events. Not all of them necessarily before the court, or but I've probably been in front of courts 7 or 8 of those 20 occasions. And I have been impressed with district court judges and with tribunals, predominantly the AAT, something else, and patents examiners on multiple occasions, because quite a number of them were patents cases, because they have worked at it. They have asked questions, and they've demonstrated in their judgments that they'd listened to and tried to understand what the experts were trying to convey to them. The opposite is true in the superior courts, both Supreme and Federal. I have been very disappointed with my experiences. They are laid out in the preface. They're the sorts of things that are somewhat pejorative, and therefore one chooses one's words extremely carefully, which I can do in a preface, and I can't do standing up here extemporising. But I have had very disappointing experiences as an expert witness in front of the superior courts in Australia. It has been apparent to me that there's been not only misapprehensions and ambiguities, but there have been misapprehensions and ambiguities that have been significant to the reasoning of the judges and the outcomes of the cases. And I think it's important that judges come to understand that their credibility is not always strong when it comes to their demonstration of technical understanding in the cases that they're dealing with, at least in my fields. There's a couple of constructive things that I can suggest from my limited experience of these matters, and this is not academic research, this is experience as a paid hand. One is that amicus curiae submissions are almost always dismissed in Australian courts, and I think that's unfortunate because they sometimes have more than a little to offer. That's said more as an advocate. The second one is that I find it blithering that the courts continue to accept that technical evidence and expert evidence comes through the filter of the parties to the case. Now, a good expert works extremely hard not to be unduly biased by the perceived interests of the person who's paying the bills. That's a given, because otherwise you're going to be torn limb from limb in court. It's not just a question of integrity and principle, it's a question of practicality. But that's not how the game is played out in court. And once again, in the preface, I've got a little bit of gory detail explaining why I use the word character assassination as being the primary purpose that barristers have in mind when they cross-examine an expert witness. Because if they can assassinate the character of the expert, then the content doesn't matter and they don't have to get down to tin tacks and fight over the real technical issues. And the judges appear to be quite happy with that idea because they are ex-barristers and because it's awfully hard work to understand the gobbledygook that some of us experts write. So I think that getting experts dealt with directly by the courts would be a heck of an improvement and would lead to fewer misapprehensions and ambiguities. Let's pick one particular area that is directly relevant to the final couple of arguments I'm going to run. We used to have really simple ways of developing software. Back in my day, when I was a programmer and a project manager, we used algorithmic or procedural languages. We were quite explicitly dealing with a solution. We knew what the problem was that we were trying to solve. When the fabled rule-based expert systems, thank you Patrick, came along some years later, these don't actually deal in solutions or in problems. They define something about a problem domain, is the way certainly many of us describe it. So the idea of a problem at any given time may be difficult to work out when you're using an expert system. It may be possible, it may be impossible, it's most likely somewhere in between the two. But wait, there's more. A later generation, which is the current vogue, is what I call empirical. Empirical techniques is my description of it. It's been my description of it for 30 years, but it is dealing with such things as neural nets, but machine learning and whatever AI is, AI/ML approaches are in this same cluster. And these deal in heaps of data. That's why I use the word empirical for them. You basically get a shovel and you just pile a whole pile of data into something that has a very small amount of preforming to it. It's not totally without some logical structure, but it is largely without structure and it is largely data. What problem? What solution? What problem domain? There isn't any in the software, and you can't, I better be careful what word I use here. You can't infer a problem, a solution, or a problem domain, or perhaps to say it even more safely, you can't reliably and non-contestably infer a problem, a solution, or a problem domain when you are dealing with sixth generation software. That is a serious challenge to humankind, and it's a serious challenge to the courts. One of the challenges, I had to decide which of the various challenges I was going to highlight, so I had to pause and remember where I got to in my preparations. One of the challenges is in the copyright space. Okay, we're stuck with this. Oh, we were talking about horses before, weren't we? With this camel that is the Copyright Act applied to software. Everybody knows that a camel is a horse designed by a committee, right? Okay, so that's the current definition in the Act. It's a set of statements or instructions in order to bring about a certain result. Third generation, no problem. Fifth generation, small amount of concentration required. Yes, I'd be very surprised if that wasn't held to be proper subject matter. Sixth generation, go for it, all you sophists out there, sorry, barristers out there. Do what you can to try and make that fit to that. I think is an extremely challenging thing. It doesn't greatly worry me. It will make quite a few lawyers quite a lot of money someday, but that's not my business. I'm much more concerned with law as a weapon of policy than I am with law as a means for lawyers to make money and for problems to be solved between two large corporations. So go for it, fellas. This will be good fun. But there are other problems that arise from the sixth generation, because where we get to is that if you don't understand what the problem is, if you don't understand what the solution is you're trying to gain, if you don't have a proper mapping of the problem domain you're studying, how the heck do you come up with a rationale that explains how you inferred, how you reached your conclusion? You cannot get rational explanations out of sixth generation, and in many cases you can't even get rational explanations out of a fifth generation. A tool, software developed using fifth generation tools cannot give you the explanations you need. So what does that mean about decision transparency? How do you explain to the welfare recipient that they breached the law because, when you cannot come up with a rational statement after the because? That's the situation we're in. The reason I've given that specific example down the bottom of the Centrelink fiasco only a few months ago. And also the way in which we've sold our credit data to an American corporation, which is now bringing in something that we did without for many, many years, which was these kinds of approaches taken to credit data in order to come up with scores for people. Horrible direction we're going in, and the effect of that is, of course, that we destroy accountability. So I think we've got some serious problems in this. I'd love to spend some time on the abandonment of reason and the deification of data, but that's somehow another story taking things a little bit too far. So, with that background, I then sat down and read the papers, hoping I'd find something in the papers that would give me a hook. And if not, I was going to have to change my direction a little bit, wasn't I? It's a very interesting set of 6 papers. They're fairly diverse. There's a little bit of clustering, but they cover quite a bit of territory. David Lindsay from Monash University, a co-author of Graham's and well known to me through the Privacy Foundation in particular, was looking at injunctions to block access. It's a very careful, being David, and very readable study of this area. And it did indeed give me the hook that I was looking for and worried I wouldn't get, because he noted a particular apparent misunderstanding, which was a conflation between 2 ideas. Now that conflation between 2 ideas, if you can remember back a little while ago, ASIC were inane and implemented some blocking, and as a result the world tumbled to the fact that Section 313 of the Telecommunications Act has been abused for quite a few years by quite a few agencies. I don't know how many people of you play in this game, but that was a very specific instance of exactly what David's drawing out here, and something that I spent rather too much time, or wasted too much time, trying to convey to a Senate committee a couple of years ago. So there's a lot in David's paper that's of interest and also fits into some of the themes that I was interested in. These 2 papers form a bit of a pair in that both of them focus on e-money. I'm mindful of the fact, Catherine, that A, you're here, and B, I haven't actually put a square brackets behind your paper. I've put one behind the pair of papers. I don't know Catherine, but I know she's here somewhere. And I think she might be the only author who is here, so from this set, so I should recognise you. These were very interesting in looking at e-money, and the important thing to me, given the lenses that I was looking through, is that part of the problem with the e-money world at the moment, and trying to work out what the law does with it, what regulation more generally does with e-money, is that it's being treated as something that it isn't, because that's what the law does. The law deals in certain things. It has particular definitions already in place. That's what technology neutrality means. Obviously, everything will be fitted into the existing basket of concepts, won't it? And it doesn't fit. These things are different and they need to be approached differently. Otherwise, you will have some serious policy problems arising. So both of those are interesting papers and well worth a visit. This was a quite different paper and one dealing with a contentious and worrisome topic, which is a current theme in Australian society of domestic abuse, and looking at technology facilitating domestic abuse. The thing that, and it's really short when I trivialise the important topic by saying, and the reason I'm interested in it is, but that's what I'm going to do. The reason that I was interested in it was that it challenged me because mostly I argue for more specificity. You must deal with the thing as it really is and don't pretend it's something else and do everything by metaphor. Don't apply old ideas, apply new ideas to the new things that are out there. But here my actual stance is a little bit different because if we had a generic right of action in the privacy field, it would have given us mechanisms already to address the revenge porn issue in particular. So I actually found myself arguing against myself in reading this paper, and it's always good when that kind of thing happens. The last couple of papers also form a pair in that they are dealing with the effects of technology during trials, a couple of rather different cuts to the problem areas, and once again, the particularities of technology are really important in these analyses. So I found a lot of value in this, in all 6 of these papers. Oops. A couple of thoughts that I wanted to throw in at the end, drawing on these themes. The first one is that I was proposing and have proposed in the preface that we've got to be careful, we've got to have a principle in trying to apply this technology neutrality. And that was the principle that I was suggesting. You've got to get the scope right, otherwise you are going to really muck this up. And of course, my proposition is tested by that 4th paper on the revenge porn topic in particular. The second cluster of things that arise from this in my mind are that we thought about cyberspace as a blizzard of data. That's how it's always been projected in all the sci-fi books and all the sci-fi films. But it's a lot more than that. I've given some examples already, but is it becoming a protected enclave for devices? We now have devices that act directly on the world. And is intelligence emergent out there in cyberspace? If so, that is going to be changing our conceptions of ourselves. I thought, how can I do this graphically to try to make it a little bit clearer or more alive? Back when I was young, I joined the computer industry in 1967. It seems like a long time ago because it is. I wrote my first program 50 years ago last May. That's scary. That was what it was all about. It was a computer industry, and that modelled the world that I was playing in. It wasn't until, depending on how you look at it, the 80s, that communications really became a big part of what we have subsequently called the IT industry. The marriage, as we called it, of the computing and communications industries changed the game dramatically. It's kept changing. It's really important that we understand that is not the end game. It's moved on. Robotics is a problematic suite of different technologies, but it has all of the elements of it have in common that there is something within the system that can have an effect on the real world, a physical effect on the real world. Now, while ever it is the dispensing of banknotes, we do still have ATMs, they haven't all been closed down yet, and I actually used one today. When that machine pokes things out, when the machine up top draws my card into the belly of the machine and then returns it later on a little tractor, each of those is a robotic action. Those ones don't scare us much, do they? Some of the other things that robots do, particularly as we let them loose in the real world, definitely do, or should, worry us. Computers have migrated from playing around with carburetors and fuel injection. They aren't just calculating, given the wear and tear and the temperature of the vehicle at the current time and 14 other factors, how much of what should I poke inside that chamber. It's moved way beyond that. Now we are talking about autonomous vehicles, and Volvo hopes that Uber is serious about that order. You had heard about that order, hadn't you? $1 billion worth of cars on order as driverless cars to get rid of Uber's troublesome drivers. Those kinds of effectors we've got to be really concerned about, and all of this is within the context of computing and communications. It's inherent in the way in which robotics is working. It's all tied in. And intellectics may or may not exist, but will they tell us when they invent it? The robots, I mean. We have people out there who are saying that reason is on its deathbed. We don't need reason anymore. We can delegate it all to the machine. We can do it all by correlation and let our wonderful calculations do it for us. That kind of delegation gets really interesting. It's been done in sci-fi. Arthur C. Clarke did it to death. But people aren't taking any notice of Arthur C. Clarke anymore. So I think we've got to watch ourselves where humankind's concerned. That's maybe not your interest, certainly not my interest. I'm dead before any of this stuff really starts to cut. But I've got children and I've got grandchildren. And I really do wonder what it is that we have been sleepwalking our way into right now, and which you lot are going to be instrumental in paving the legal way to enable, to ensure that it actually comes about so that the large companies that want to do these things get to do them. You're the people doing it. I'm really quite concerned about how that's going to work, and I do suggest to you and your successors that thematic issue is needed not only on the specifics, and you've got a very good one here on the specifics. We need a thematic issue also on the quite general issues of where the heck is this technology going, and what impact will that be having on humankind, and through it the law. Thank you very much.
So good evening, everyone. It's my happy task and privilege to offer a vote of thanks to Dr. Roger Clarke for, where is he gone? Oh, there you are, sorry. For a characteristically entertaining, engaging and compelling talk tonight. And I do so on behalf of the Faculty of Law, and in particular on behalf of George Williams, who asked me to pass on his thanks to Roger and also his congratulations on this fine issue of the Law Journal to all involved, and especially the editorial team and the outgoing executive editor, and Chris Chiam, whose vision this thematic special issue is. Roger, as you have seen again tonight, brings three qualities to this broad terrain of cyberspace and law, which enable him to be such a distinctive, cut-through voice, awakening us momentarily from our sleepwalking. The first is a nearly unmatched depth and breadth and length of experience in getting down, in his own terms, to tin tacks with the policy challenges and ramifications of developments in information technology. Really one of the most experienced operators in many capacities in this terrain through decades of work as a researcher and consultant. The second is a lovely, refreshing irreverence and straight-talking quality, which, as I said, enables him to jog us from our slumber surrounding this issue and awakens us to the urgency of this very significant, what is really at stake in these very significant transformations of society that are underway and captured in the content of this thematic issue. And third is a kind of mischievous quality and an endless curiosity that enables him to bring unlikely combinations of artefacts and forms of knowledge together, which we saw tonight in his ability to bring together cows, knees, nuclear accidents, and judges and robots all into the same arc and line of argument in a plausible way. So these three things we've seen on show for us tonight, and as he took us through an argument that was ranged from the very specific arguments against the false promise of technology neutrality and the deficiencies of legal and judicial grasp of developments in information technology to a broad sweep of what is underway before us in this current moment. So on behalf of everyone here, I'd like to to offer a vote of thanks to Roger for taking us on this little journey tonight. And I'd also like to thank, once again, King Wood Mallesons for their hospitality this evening and for their long-standing support for the researchers and students of UNSW Law, which we deeply appreciate, and also their leadership in generally in the legal space in helping to advance thinking today that really prepares us in the broader sense, practitioners, society, scholars for a better tomorrow. And I'd also like to thank all of you for coming out on a Wednesday night in such great numbers to support the UNSW Law Journal, the flagship journal of our Faculty of Law, of which we're very, very proud. And I think that's it from me. So thank you again.